rules. This is an interim arrangement till the time something regular, more of a statutory kind, comes up. So IBBI is at present a guest artist for the valuation profession. It is doing the handholding, but the profession should move ahead, having its own independent institutional arrangement. That is what precisely the committee of experts has recommended. My second interest is that IBBI is a user of valuation services. When one needs medical services, he must find a person who is competent, who is authorized, and who is accountable for medical services. Similarly, when one needs valuation services, he should find someone who is competent, who is authorized, and who is accountable for valuation services. This means that IBBI is interested in a valuer who is professionally qualified in the valuation profession, as a person is qualified in medical science or chartered accountancy, and IBBI is interested in a valuer who is accountable for his valuation services, as a doctor or chartered accountant is. This would in turn attract the talent to the profession, who will study a professional course. Only they would have authorization to provide valuation services and none else. And users of valuation services will have assurance of certain minimum quality. Let me give an example where IBBI uses valuation services. It is in insolvency proceedings. There is a requirement that two valuers will conduct a valuation of a company to arrive at the fair value and liquidation value of that company in distress. These are not the prices which market discovers, and nobody has a means to know what the price or market value is. But we expect the valuer to produce a value which is more authentic than the price itself. In a sense, a valuer competes with the most powerful creation of man, that is the market. When a market discovers a price, we construe that price to be most authentic value of the product. But market at times can go wrong in many ways than one, but a valuer must not be. The valuer must produce a value which is more authentic than the price discovered by the market. This only goes on to illustrate that the kind of competence a valuer must have and the institutional arrangement required to produce such valuers. In corporate insolvency resolution process, a valuer gives a value of a company in distress, and keeping that value as a reference, the committee of creditors compares how much the market is willing to pay to take over the company or to discharge the obligations. So we get a value from market sources, which could be a good value, bad value, but we have got a more authentic value from a valuer. And now we are comparing these two for a decision making, whether we should accept or reject a proposal. We may reject the proposal resulting in the liquidation of the company, or we may let the company live by accepting the proposal. This decision to kill a company or rescue a company crucially depends on the value given by a valuer. If a valuer gives an inappropriate value, then it's possible that we will close an otherwise viable company, or we will rescue an unviable company, both of which are detrimental to the economy. And that is the importance of a valuer in a market economy, and this is the interest of IBBI in a valuation profession. Let me give a little bit about because the kind of questions I see coming up on this web requires me to look at a little bit of the history, and I am not sure if I can respond to all the questions coming up. but I will try to attempt some of them, at least giving the thinking of the committee in proposing a framework like this. Valuation profession has a history of about a century, I believe. Organizers of this seminar, they are at least 50-year-old. Different statutes, banking, securities, tax, company, insolvency, they have the required valuation for a variety of purposes. Each statute, acting as a separate island, has focused on what needs to be valued, who can render valuation services, and the manner of such valuation. Several self-regulatory organizations like IOV, they have come up. They have tried to build the expertise generally to meet the needs of the users. Each of these users, each of these registered the valuer organizations or self-regulatory organizations, they have come up acting in a separate island, promote their respective interests, but such islands both in the side of a demand and supply, most of which are too small, lack a capacity and motivation to manage, develop, and provide a cadre of service to meet the needs of the entire country, India. This has not engendered a holistic development of the profession. Since anyone and everyone could join an academic interest, the academic interest in the profession is limited. Many valuers have told me that they have enough work, but they do not get adequate respect from the society as other professionals get. Similarly, many users of valuation services have told that they need valuation, but they do not know who to approach for valuation. He knows who is a doctor, he knows who is an advocate, who is a chartered accountant, but he does not know who is the valuer qualified, can do a quality work for the valuation I need. And yet, he will be held accountable. They approach someone, many organizations like banks, they have developed panels. They use panel-based approach. Somebody wants a loan, bank gets a valuation done through a valuer. When there's a default, at times it is realized that there's not adequate security interest. Some people say NPAs have origin in inappropriate valuations. And imagine the consequences I just told you. A company will be liquidated based on the value given by a valuer. This is the importance of the valuation profession, and in a market economy, people are using to take important decisions. Further, today every valuer gives a unique valuation of the same asset using a unique approach. The country does not yet have a valuation standard of its own. Every valuer gives a different value by using different approaches in the same circumstances, and often a customer is worse off with a valuation. The valuer who has arrived at the right valuation, who is capable, who uses proper scientific methods, he finds it difficult to defend his position because people can't have nowhere to know who has done the most correct scientific valuation and who has done a kind of a quack. There is no way to distinguish between them. Accountability and liability of the valuers is getting compromised. Values of two assets cannot be that easily compared because these have come from two different sources. To address these kind of issues, to have the respectability of the profession it deserves, to have the accountability for the users, to have the standards of service, to make a valuation an exclusive domain of qualified valuers, and more importantly, to make India in the time of a Make in India, let India serve the valuation services to the entire world rather than we depending on others. To fulfill such felt need, this has been felt for a long time, to have an institutional framework. Several attempts have been made in the past, starting with the expert group in 2003, Another expert committee in 2005. Companies Bill 2008 provided for this. A complete bill was drafted called Valuation Bill in 2008. Companies Bill 2009, Companies Act 2013, Company Law Review Committee 2016. Every time an attempt has been made to move an inch forward to make or to provide a complete framework for the valuation profession. The valuation rules issued under the Companies Act 2013 that provides for comprehensive framework for development and regulation of a valuation profession for valuations required under the Companies Act and the Insolvency Bankruptcy Code and not others. But all these efforts I just mentioned, they have acknowledged that valuation profession deserves respect in the committee of professions, while the users of valuation services need the reassurance that they have access to minimum quality of valuation services. With the 2017 value rules, we made a beginning, covered some distance. The next logical step is full respectability of the profession with a full-fledged statutory framework. In fact, as we are working, we are stuck. We are astonished how such a profession with 30, 40, 50,000 members practicing, having such a huge potential and having quite a few top-notch valuers, does not have a statutory framework, and the value professions which emerged much later, they have the statutory framework today. I am a member of a profession called Company Secretary, which got a statutory framework in 1980. But it emerged much after valuation profession emerged in the country. So I was a little wondering what was that we could not do. Why that valuation profession could not get such a framework that it deserved. The committee of experts studied all past attempts over the last 2 decades, particularly the Valuation Bill 2008, which is quite extensive. It also studied all other professions in the country. Valuation profession in many countries, which all good ones have a statutory legal framework. History of a regulatory framework of profession starting from, you may have heard of a Hammurabi Code, which is 5,000-year-old in our history, our times, which emphasize that society's interest must be kept above the interest of a professional. And then it provided 5,000 years ago, if a professional abuses his rights, he should be liable for penal consequences. We have seen also the history of fit and proper person. Most of you must be aware, the Advocates Act of 1964 of South Africa then provided that applicants should be a fit and proper person, and Mahatma Gandhi, the father of the nation, had to face this difficulty there, that someone argued that his membership in bar was opposed because he was of an Indian origin and not a fit and proper person. Though that didn't stand the test of law, yet I am only illustrating that the concept of fit and proper a person, a professional has to be fit and proper, is also a century old. We studied the contemporary thought in a design of a regulatory framework, particularly in Indian context, the work that has happened, Financial Sector Legislative Reforms Commission. Very recently under the Minister of Corporate Affairs, Competition Law Review Committee. Recently there's a committee, a high-powered committee of the Minister of Corporate Affairs on a disciplinary framework. Another in 2015, Justice Sri Krishna Committee on the profession of a company secretaries. And the most important, the latest, just has come out from the oven, the National Medical Commission Act 2013. And imagine that act came discarding another act which could not meet the requirements of India. And this National Medical Commission has become the Commission Act, has become the benchmark of values, benchmark of professional standards and regulation development of professions. we took note of the what is on the ground. As I saw IOV, many other valuation organizations, 30, 40, 50,000 valuers doing practice under different laws. We took a note of all that is there. We had long discussions with the stakeholders, registered valuer organizations, several roundtable discussions, online consultations. Based on all that, we have devised an institutional framework that hopefully meets the needs of the profession and of India. Yet it is least disruptive. But again, this is the view of a committee. Government has to take the call based on the feedback the users give to government. So, and government has invited comments. I would request all of you to give your views to the government so that you get a framework what you deserve. So now let me explain some of the features. I will get some kind of comments also here that this what it has done is this is provides a ecosystem. There are many elements of the ecosystem: valuation professional organization, National Institute of Valuers, Valuers Institute. But most of the questions I now see here relate to the valuers and users, not much on valuers professional organization, not Valuer Institute, not NIV. Of course, there is suggestion for NIV that for valuer that it should be called a chartered valuer, not a valuer or registered valuer. These are not. These are actually. You should get the name what you like, what really conveys what you are. Please suggest, make all suggestions to government. Feel free to suggest that yes, you should be called chartered engineer, chartered valuer. We know we have a profession called chartered accountant. So nothing wrong in that. Absolutely, you are free, suggest all that. But most of the things are coming around. There are two key elements: the users and valuers. Valuers have no role if there is no one used to use their services. Similarly, users have no access to valuation services if there are no valuers. The rest, Valuer Institute to National Institute of Valuers, all are there to support these two people, valuer and user, and protect their interest so that there is a market with the discipline. Valuer provides good service, computes to provide better service, users are benefited. This is what the two components are. So they must have a very harmonious relationship, and COC has tried to achieve that. But I get feedback that some people say that users have not been given a very right deal. Their interests have not been fully protected. But simultaneously, I also hear that professionals feel that they have not been given adequate protection. I am not going to take a view who is right, but let me state the facts. The proposed bill in its long title states the objective. Objective is, first order objective is the establishment of an institute. For what? To promote the development of the valuation profession. Then to regulate the profession of valuers. Then regulate market for valuation services. Then protect the interest of valuation, users of valuation services. Usually, as you know, market in any environment, market develops fast, then follows the regulation. Growth becomes fast and robust if there is a regulatory framework. Regulation is there to give a comfort. For example, because I am from financial market, spent long years in financial market. When derivatives market came first time to the world, transactions took place, but volumes were not good. Liquidity, price efficiency were not good. Markets grew, got respectability only when a regulated framework was put in place. So development and regulation go hand in hand. You cannot regulate something unless there is development. If there is no development, there can be no regulation. Regulation can only come when a profession starts developing, and a profession can develop only when there is a comfort of regulation. Development happens, market expands. when stakeholders feel comfortable to use more and more of the services. Look at the long title of the Institute of Company Secretaries Act 1980. This is an act to promote development of and regulate the profession of company secretaries. So the traditional approach has been to create a regulatory body, keep two in responsibility about development and regulation of a profession. And why do we regulate and develop a profession? Because it is not to create work for professionals. It is to serve the clients, users, or society. The report has quoted one beautiful sentence from Lionel Browne. Right to regulate practice comes from the right of the people to protect themselves. A primary function of the state is to protect the interest of consumers. Most modern statute, all market economy statute after 1992, look at any act. These are there to provide protection of users. SEBI is an act to protect the interest of investors in securities. IRDI to protect the interest of holders of insurance policies. PFRDI Act to protect the interest of subscribers to schemes of pension funds. Competition Commission of India Act to protect the interest of consumers. See National Medical Council Commission Act 2019, a very long title, all focused on protecting the interests of users, patients. They should get good quality medical service. So this draft bill now endeavors to balance, while interest of users is important, but it cannot go to the extent that a professional is subjected to harassment. Chapter 4 of the report explains to what extent regulations should be there, why regulations should be there at all. The economists believe that regulations are necessary to address market failure. Market failure arises only from three reasons, namely information asymmetry, market power, and externalities. Take the example of, I am not going to be very academic here, just take an example of information asymmetry. The user of valuation services, he has no information about the capability of a person to provide valuation services. Wherever he has, he cannot assess that a particular person is capable or good. Further, valuation service, like any other service, being an experience good, until I try out, I can't say that this doctor is good. Being an experience good, until I use, I can't know its quality. How do I address this market asymmetry, information asymmetry problem? The law addresses this by providing entry norms for the profession. That means only people who have qualification and meet certain standards, only they can come in to provide services. Then I know this is a doctor authorized by medical council, this is a valuer authorized by such and such institute, this is a chartered accountant authorized chartered accountant. Then I don't have to do much due diligence. I can comfortably go to any chartered accountant, any valuer, and get the service. So requiring a entry norm is a regulatory tool. This is how valuation profession is regulated. But this is not that anyway here valuer is put into any kind of difficulty. Every profession has entry norms, and there are similar such norms. In lieu of what? While we say that no one can practice valuation unless a qualification, we simultaneously say that only a valuer is allowed to practice valuation profession and none else. First time there's a proposal here to say that only a valuer can do valuation practices. If you look at the Architects Act, today also it does not provide for that. It says architect registered with Architect Council can practice and someone else also can do it. So this kind of a reservation that valuation can be done only by a valuer. These are the elements of regulation. When something is reserved for you, then there has to be an entry norm. This is the rationale. Every proposal in the bill has a rationale, and that rationale is at the root that address a market failure. But then how do we protect consumers? As I mentioned so much, consumers should have some right. What is that right? They have a right to give or file an information when they have a complaint or a grievance to the National Institute of Valuers. You cannot say that users cannot have any remedy wherever he is suffering, but that does not mean that every information that comes to the valuer, it points out there is something, some lapse on the part of a valuer. So that's why look at chapter 13. It provides chapter 3. Most important part is says that there is section 41 subsection 3. That says that the valuation is a matter of opinion. This cannot be examined. The merits of valuation cannot be examined by anybody unless one proves it is mala fide. If somebody can prove that it's a mala fide, it is fraud, it is corruption, it is something, I don't think we have to protect that person. But if he has done any professional mistake, law protects here. Law says that, very explicitly says that nobody shall examine merits of a valuation report arrived at by a valuer unless it is mala fide. And this kind of blanket protection you do not have in any statute today. Any Indian statute, look at, this protection is not there unless somebody proves that it's a mala fide, nobody can touch it. And even touching you also, there's a detailed process. There's a fact-finding process, show cause notice, principle of natural justice, access to expert opinion, provision of appeal, and within the valuer organization NIB, there is a separate law department like the judiciary works with a Chinese wall so that frivolous allegations are not entertained. And when I told you that about the valuation certificate, unless somebody shows mala fide, nothing can be done, and then it gives a lot more examples. But let me move to now the penal provisions. First is penal provision is attracted only when it is a mala fide. If it is a genuine, honest mistake, it could be a warning, it could be a some reprimand. It could be, it provides varieties of things. Some people consider that, I have received both feedbacks again. Some say that following from users are not well protected, they say that not enough, not adequate penal provisions are not really harsh, it should be made more harsh. Some say that it is excessive, it is draconian. So first point is that please look at, first I told you, unless mala fide, nothing can be done. Second is, section 41 talks about penalties for 3-4 kinds of people, namely valuers, valuer institutes, valuer professional organizations. So wherever you find penalty in crores, these are not for valuers. These are for valuer institute, valuer professional organization, but for valuers, it is in the lakhs. What does it say? It says warning, reprimand, improvement of capability, cease and desist, restriction on rendering valuation service for a certain period, disgorgement of unlawful money you have made, give back the unlawful money. And after these 5-6 things which are actually no punishment, then there are 2 more. One is suspension or cancellation certificate. Everywhere, doctor or advocate, anywhere, if it's a grave punishment, registration is withdrawn, and penalty can be up to 2 lakh or 3 times of the unlawful money you have made. But then look at this, the process to be followed. There's a fundamental rule in the country called rule of proportionality. This is given in section 42. That talks that the adjudicating panel, which is also not a one man, it is a panel. See the kind of protection. A panel of people will apply mine. There are 2 layers of appeals. Mala fide, unless mala fide opinion cannot be examined on merit. Then the proportionality rule comes, which says that you have to consider the nature and seriousness of alleged contravention, including whether it was a deliberate. If it is deliberate, yes. Consequences and impact of such contravention, whether any unfair advantage was taken by the valuer, what loss has been caused to others, what has been the conduct of the valuer after occurrence of the alleged default, alleged contravention. So these are the things which we talk about the proportionality. So the due procedure, a well-defined fact-finding process, a separate administrative law department, panel of adjudicating officers, 2 layers of appeal, valuation as an opinion. They have to follow rule of proportionality, principles of natural justice. All these people, some people that are giving much protection to valuers. But committee felt, given that it is an opinion, they need this extra protection than any other profession has. Some feedback I see here that it has provided same inspection investigation for all valuer institute, valuer professional organization, and valuer. Yes, law enables inspection and investigation for all 3. But when you work out the details in inspection manuals, when the national insurance valuers comes up, those will be quite detailed, then those will be different. The valuer needs a different type of inspection than a valuer institute needs. But the law, this basic law enables that details to be provided later on. So I would suggest that neither the user should feel that valuers are not being, there is not adequate provision for valuers. Valuers should not feel that there is an excessive thing. We should rather think both valuer and user, we should think that let's not commit any mala-fide mistake. Only when there is a mala-fide design, then only the amount of penalty arises. Otherwise, the question of penalty does not arise. Even if it arises, it's a proportion. Another issue that has come up is some people feel that the bill has favored companies, foreign firms, big valuation firms. Some others feel that bill has discriminated against companies, foreign firms, big firms. They say that companies have been allowed, but with very stringent norms, and subsidiaries have not been clearly allowed. It will be done sometime in this and sometime in the future. Now let's understand the facts. I am again not saying whether we have favored, we have discriminated. Attempt has been to provide a competitive environment. Let's look at the bill does not exist today, yet there are companies, foreign firms, big valuation firms. Then how do we say valuer bill is providing something? If these are there, companies are there, foreign firms are there, big valuation firms are there, and users are using their services, finding a value, why should bill ban them? Are they adding any value? If yes, if you ban them, you will be penalizing the users. Why should you penalize our users, prohibit them from good service? So they are there because both business and profession are becoming complex, and it is beyond the capability of an individual professional to meet the vast and complex needs of a client fully, while the client often looks for one-stop solution for his needs. For some disease, some treatment, I need to go to clinic, one doctor is good enough. For some treatment, I need a dozen doctors. For some treatment, I need a hospital. Needs are different. And there is a space for an individual doctor, space for a team of doctors, space for hospital. It's all the business chooses. If users finds a value, there's no reason to deny the user some good service. Otherwise, you will be penalizing a client who wants to use the services. The question should be, are they doing anything illegal? If illegal, penalize them, rusticate them. The fear that, they sometimes fear that big firms are there, we can't compete. This has been proved again and again wrong. We are in a time called Monopolies and Restrictive Trade Practices Act. We had several restrictions on foreign investments. We were afraid that big entities in foreign investment will do some damage to us. But all these have disproved with the large scale liberalization we had from 1992. Today we don't find any problem with monopoly or a big farm. We rather promote competition. If somebody is giving good value, supposing I want to buy a shirt, I want a good shirt. I will not bother whether shirt is produced by a big farm or small farm. We should allow every small farm to grow big, have the scale, then only you can compete with the world. Actually, as I mentioned earlier, the idea is to have the profession which will provide the valuation services to the world. Today we take pride that India provides the hub of medicines. It is the pharmaceutical hub of the world. India should be the valuation hub of the world. That is what we should produce, rather than not allowing our people to grow. So the right approach is not to deny something to someone just because it's a company. But let me make also clear that this is a profession. We must maintain the professional character. It can be a company, it can be a partnership, it can be allowed to have the scale, but it must still remain at the root, the professional. What does it say? It says that bill doesn't promote anybody, discourage anybody, allows a level playing field, competitive environment for valuers to compete at marketplace, and it believes that there's a place for everyone, one's individual to a very large part. Bill allows body corporates and companies to provide valuation service. And mind it, this is not something new. This is in vogue today in the valuation rules in 2017. The expert group of 2003, 17 years ago, had recommended the firms and companies to be valuers. The Parliamentary Standing Committee on Finance, which examined the Companies Bill 2009, in its 21st report recommended that firms, body corporates, and professionals, even it went for multidisciplinary firms, allow chartered accountants, etc. Only when you allow multidisciplinary firms, you will have big firms in the country. It also recommended that prescription having only registered valuation partners should be dispensed with. So today, SEBI allows registered merchant bankers to carry out valuation. They are all companies. In several foreign jurisdictions, the professional form a firm called Professional Services Corporation for rendering services. The firms and companies are allowed to practice valuation in many jurisdictions. The rationale of allowing individuals, firms, and companies all together has been explained in para 4.33 to 4.41 of the report. But as I just mentioned, bill retains the professional character. First thing it does is that you must be a resident in India to do valuation practice in the country. You must have the certificate qualification from Indian Valuer Institute. The partnership firm can have partners, directors. All of them must be residents in India, must be fit and proper person. The people who will do service, majority of the partners, majority of the directors must have certificate of practice. They must pass examination, they must certificate practice, and only they will be allowed to sign the certificates. Imagine it is an Indian having Indian qualification, joining hands with another Indian friend and doing evaluation. And we want this firm to grow up and serve the valuation industry in the world, not only in India. So the law enables one to provide services on its own through a partnership, through a company, and law enables a user also to use an individual valuer, a valuer firm. It's their respective choices. Unless there is any market failure associated with that, there is no reason to restrict the choice of a user or a valuer. However, as I just mentioned, as regards subsidiaries, there is a possibility that the professional character would be diluted to some extent. In fact, the committee had two different views we could not conclude. So we neither prohibited nor allowed. We kept it that national issue valuers let it decide when the need arises and provide in its wisdom decide when it considers appropriate, provide appropriate safeguards. When it's satisfied, let it allow it, let it not allow it. So there is something, that's why it has not been clearly allowed. As I mentioned a little earlier, there are a few questions also. Our focus has been, it has to be least disruptive. The valuers who are registered today under valuation rules, section 50, subsection 3, allows them to be valuers under the new framework. Look at every law, Value Advocates Act. In the beginning, the people who are doing practice all have been enabled to get into the mainstream with some sanitization, some procedural formality, some top of things. None has been discarded. Every legislation look. In the beginning, as I told, I am a company secretary. I know also people who did government diploma in company secretary course, they are also taken as a member of the institute. When the institute was formed in 1980, Company Secretaries Act. So every profession in the beginning, to be least disruptive, it takes, because it's not that the hard work has happened over 50 years, 100 years. They are the repositories of knowledge today. You cannot just discard them. They have to be taken. So everyone who is doing service has to be taken, but a formality has to be there. Today, who are registered valuers under company's valuation rules, they will be taken. Valuers who are doing practice today, they have the qualification what has been provided there. They can, today we have a valuation examination, 2-hour objective multiple choice examination, complete the training, take the examination, you have qualification and be a member. And this door is open for 2 or 3 years. Again, these are all, some of you have views. It should be open for 4 years, some 5 years. These are all matters. I don't think one should disagree with this. Window can remain open 1 year, 2 year, 3 year, but it can't remain open indefinitely. Those who have qualification, they should be able to come in without any requirement, come in as other valuers have come in through valuation rules. Even those who do not have a qualification, who do not have a bachelor's degree in engineering or chartered accountancy, but they are in practice, if they have 5 years experience, let them also come in, but taking a shorter program, bridge program of 3 months or so, we call it a limited valuation program, which will be 300, 400 hours. Those who have no experience, who are not in practice, but have a degree in engineering, degree in chartered accountancy, some course, they want to sing. It happens when a new profession comes up, many people find value, they want to join. If such people are there, somebody has done a graduation somewhere, there will be a 2-year shorter program, complete it. This is called a graduation valuation program, and then join the profession. And then the door is open for the students just after +2, when everyone chooses a career, he will also choose one among them. Career options will include valuers. That is the time we have to attract the talent. That is the time we have to get young blood. So that's why all the valuers in existence today, for them there is a transition. You can give your views, even on there can be views on many aspects. How long that transition window should open. Whatever qualifications are there, those qualifications should be modified. That should meet your requirement. But there are also similar questions I get about the transition provision for the Valuer Institute. Some people are asking that I am such and such university, I haven't doing this valuation course. Why can't this bill recognize me as the Valuer Institute? The bill does not recognize or de-recognize anyone. It only enables the National Institute of Valuers to recognize a Valuer Institute meeting its requirements. Requirements have to be specified. somebody has to satisfy, and then offer the courses, get a registration from National Institute of Valuers. So today no one is recognized. Those who have ability, they should come, demonstrate it, and offer the course, continue to meet the standards. I got also a query that somebody asked, I have been running a 2-year program for last so many years. Should I not admit students in the next academic year beginning in June? I do not want to advise you what you want to do. This is your commercial decision. But this law discussion process is on. We do not know if and in what form the law will come. So you take your commercial decision. Whenever this law comes, law as it is provides how to be recognized. If you want to be recognized, then you get in. There are questions also that whether I would require to be a valuer institute, require AICT approval, require a UGC approval. No. This is like the chartered accountants profession, company secretary profession. These are the professions, these are the qualifications recognized. Course is designed, syllabus is planned by the Institute of Valuers, National Institute of Valuers. These do not require anything. This is like somebody becomes a member of the chartered accountants by passing chartered accountants qualification. Similarly, you pass valuer qualification, will become a member of the Valuers Institute. There's a query also that can I be in employment and also in valuation, or is it a full-time valuation profession? In course of time, the committee has adopted a very flexible approach. There are many things. This is also flexible that at least to start with, it cannot be full-time. We know today many valuers are doing practice today who are not full-time. They are doing extension of another profession. They are doing part-time. And if you force someone to become the valuer full-time, he may not get enough work. But when the profession matures, when everybody has work, at that time one may consider to make it a full-time. That's why it does not say, law does not say anything. But law in its reports, in a report it says that it has to be part-time today. In course of time, if required, it can be made full-time. So if it is not full-time, you can do part-time today. You can do another, like today there is a chartered accountant who is an insolvency professional. That kind of arrangement will continue. But you cannot be in employment. Because when you are in employment, time is not at your command. When you are in a profession, you are dealing with clients, time is under your control, you can decide. So along with employment, you cannot be in valuation profession, but just being valuer is not a prohibition. There's another step. You can be a valuer while being in employment, but you need a certificate of practice. Only when you want a certificate of practice, then you have to resign from the job. When you want to take up the job, surrender practice of practical practice certificate. This is the provision in a company secretary, in advocate. Everyone surrenders his certificate of practice, takes up employment. You want to practice, give up employment and come, but you cannot be in practice and employment simultaneously. As I told you, it has a lot of flexibility. Today it says there are 3 asset classes. Let's start. But what is the domain scope of each asset class? You can expand it. In land and building, you can include pisciculture. You can bring arts and jewelry. You can take out, you find that jewelry has become an independent discipline, there is enough market, let it be a full-fledged discipline. You can add a new asset class. You can contract, subtract. You can do anything, entire flexibility, all with the changing times. Because we believe that this law has to last 100 years. There should be enough flexibility for National Institute of Valuers to serve the requirements of the country, even without a change in the law or going to parliament. Similarly, the recommendation is that make this valuation by a valuer mandatory for valuations required under Companies Act and the Insolvency and Bankruptcy Code. Thereafter, law enables. You want valuation to be done under Wealth Tax Act, you want under banking, you want under security laws, you are welcome. Some of you have a query that why not you force everybody, why not you force the banks to use this valuers, qualified valuers member. I always believe in the market. We should give a value, then bankers would find a value, come and use it, not force anybody. Let's not force anybody. Let's create a profession which gives value, and therefore, because it gives value, people want to use it. So it's not a good idea to mandate anything, but enable whosoever wants to come and use it, you are welcome. So this kind of flexibility, enough flexibility, this bill has kept. Just by the way, there's a science in this, that this is called incomplete law. Law is made, skeleton law is made, but full law, detailed law is allowed to evolve. And this is the modern practice. This is the market law. So many things are flexible, that will be tailor-made. Again, based on what? Based on there's a committee of valuers comprising exclusive valuers. And whatever that committee recommends has to be considered by the National Institute of Valuers. Binding. It has to be considered and rejected at best. So whatever market wants, it has the flexibility, should allow the profession to evolve accordingly. This committee, as I told you, one practice we followed is that we wanted to engage with the stakeholders as much as we can. We have recommended the same thing to National Institute of Valuers. We have recommended the bill that before National Institute of Valuers makes any rule, regulation, circular, guideline, it must have a standard written down procedure to make regulations. One specific thing has been told, that for making regulations, it has to do a cost benefit analysis. It has to do a public consultation. We did the public consultation. Government is now doing another round of public consultation. So the whole purpose is that bill is really grounded on the reality. We are not away from reality. That's why let's have as much consultation as possible. Now that government has opened up for consultation, I request all of you to submit your views, seek changes, add, subtract, elaborate, and not allow. There would always be a situation that this consultation process has also some demerits at times. What happens is that there are some small set of people, vociferous people, who submit the same view again and again, who organize, lobby, but vast majority of the users particularly, they do not come up because they think we are least affected, or they think that we are not organized, we do not have a collective way of speaking. So majority people, they keep quiet. A small minority pushes something, and ultimately that becomes the law. So therefore, instead of getting into that, allowing some organized vocal interest groups to have excessive influence, please let everyone participate, contribute, and deserve the law, have the law you want. COC, the committee of experts, has given a view. Nothing is yet cast in iron. Your views will help to government to take a final view. Ball is in your court. If you wish to belong to an elite group of professionals, have the respect of the society, to be respected at par with a doctor or chartered accountant, please make suggestions to improve the bill to meet your requirement. Please join the endeavor to make yourself not just a valuation professional, but be the most valued professional, and make this society proud of you. And more importantly, let India serve valuation services to the world. Thank you. Thanks to IOV and Mr. Goel for giving me the opportunity to speak to such a distinguished large audience. Thank you.
Sir, thank you very much, sir. And it's my pleasure, and I can foresee that the way this we are moving forward towards the bill, India will, my optimism that India will become the global leader in valuation, because we throughout all the through nationally, but globally. And so our interest of
I
users,
think
because there were some
problem in his voice.
Am I audible? Am I audible, sir?
Yes, I can hear you.
Yeah, okay, sir.
I can hear you, Mr. Goel.
So there were major concerns like protection of the interest of users. There was some confusion amongst people where they were feeling that it should be in the larger interest of all stakeholders. And of course, regarding apprehension regarding the subsidiary companies being allowed. And similarly, how the profit, the penalty on the basis of the loss, and similar other major concerns were there. And so you have very elaborately, you have addressed those concerns and explained those. Even then, there may be some specific questions, and if you allow, we can ask our participants only a few questions. They can ask you very specific, which they may feel that those are not covered. If you allow so, sir.
Yeah, I would be happy.
Okay, sir.
But you also being a member of the committee,
I know.
you should also respond to your members.
Yeah, we have. You're right. You're absolutely right, and I have done my best to reply also. So I think we can take a few questions. Saurabh. Saurabh.
So the first question, Mr. Vishwajit Jadon, he can ask the question, sir.
Okay,
Yeah.
thank you. Good evening, sir. I have one small question. What shall be the status of valuers who are already practicing as registered valuers under Section 34AB of Wealth Tax Act? You know that this is the oldest and largest utilized statute till date, even after enactment of Companies Act and IBBI rules for registered valuers. And it was a widespread request that the registered valuer under Section 34AB shall be accommodated at the time of IBBI rules. But it was not taken care of. Argument was given by IBBI that the registered valuer under 34AB have not passed any exam, so they can't be taken. Another point was given that it is a different statute, now it is a different statute. See, if we have to see as one nation, one government, then there should not be many statutes. And in fact, the intention of this draft bill itself is consolidation. So at this point of consolidation, it will be very reasonable if we can allow 34AB to be on board. Maybe if you have an insistence of an exam, they could be allowed to go for a training and exam, and this qualification should be added at least in 49(1)(d). See, nowhere there is mention of this. When you are accommodating the history, accommodating the existing things, this is one existing thing which is not accommodated. Please.
Okay. See, this, we do not have a law, separate law for chartered accountant for income tax, chartered accountant for industry, chartered accountant for audit. We do not have, no profession is like that, or company secretary is like that. But today, for historical reasons, we have an income tax act or wealth tax act or some SEBI law, some other law. So different users have found a way of using the valuation services to meet their requirement. Now, this is an attempt to have a comprehensive law irrespective of legislation. This law does not recognize any valuer. Like as I just mentioned, this law does not recognize any valuer institute. We are starting on a clean slate. Everyone has to meet the requirement, but there is a way it provides how transition will happen. As you rightly mentioned, there will be some examination, some training. So if you do not have a qualification also, there is a way to come. That's why please remember it says that this says two things. Those who are doing practice not having qualification, still they can come with a bridge course. And those who have qualification, they can come in a more direct way. So there is absolutely no restriction that somebody practicing in 34AB or securities law or any other law he can come in. But as I told you, even those who are those who are already registered with IBBI, they all have a qualification, they all have passed an examination, and they have come in. Same route is available to everybody, those in 34AB or securities law or elsewhere. There is no preference, no discrimination. Everybody will come through this same route, and there is no separate route for different people to come in, different ways to come in.
Next question, Saurabh, we can take up the next question.
I think the next question Mr. Patekar can ask.
Yeah.
Yeah.
Good evening, sir. So my one observation is regarding the architecture or framework of other institutes, like in ICSI, ICAI, even in Bar Council. So elected bodies are there in those institutes. So why there shall not be any election constituent bodies under NIV? And is it not our fundamental idea? Is it not against our fundamental idea of democratic mechanism of the institutions?
I just mentioned to you National Medical Commission Act 2019 only, very recent, 6-month old. And see the way we have moved, the country has moved. And you read the parliamentary committee reports why this model was adopted discarding the earlier medical commission law. And please also note that this committee of experts had members, presidents of 3 professional institutes, president of Institute of Compensation of India, president of Chartered Accountants of India, president of Cost and Works Accountants of India. They are all heads of elected bodies. They were also part of this committee. So there has enough thought has gone to structure in this manner, while allowing also valuers have a legitimate role through Valuation Standards Committee, through Valuers Council, through Valuers Organization. So there are ways. This is a model which is called, which has an element of state and an element of market. So both regulator and regulated, there is a hybrid system. And these are the, as I told you, the basic thinking, FSLRC, CLRC, a lot of thinking has gone. The world is moving the regulatory structure. We are going on a modern regulatory path.
So we can take up the next question.
Mr. P.T. Suresh. Mr. P.T. Suresh, are you audible? Are you able to see?
Yes, I am hearing.
Yeah, please
Sir.
ask your question, please, sir.
Good evening, sir. Sir, we are the valuers, sir. We are having that much numbers. We are having more members, sir. But the representation for the valuers, to my opinion, is very low, and including in all the committees, such as Committee of Valuers, Committee of Standard Committee, Governing Council, etc. The valuers numbers is very low, sir. So that we can our valuers can represent more.
Please give your views, what changes you want. Government is willing, open hands, government is welcoming. Please come and tell what changes you want to meet your requirement. As I told, committee is only a view. One view that has gone through the process, but the decision, before decision, you are being consulted. Tell that what you want. Not to me. Tell government, not to me.
I want the bill should be valuers friendly, sir. That should not be. Why? Because we are fighting in more area.
I think Mr. Suresh, your views will be taken.
Since you are a user, you would like it to valuers friendly. When you talk to user, sorry, you are a valuer, you want it to be valuer friendly. When we talk to a user, he wants it to be user friendly. And as I told you, there are both concerns are genuine. Users want more accountability, valuers want less accountability. So you have to have a balance. And here attempt is balance. What is that protection not there for valuer? Tell me. If it says that in no law, there is a protection like valuer's certificate is an opinion, it cannot be examined on merit. Not even in the medical science, not compulsory, not chartered account, this kind of statement is there. This kind of protection you don't find even in any law in the world. What else? It is protection that only when you are malafide, you are fraud, you will be liable. And I don't think even if you forget about valuer bill, if it is malafide, Indian penal code will be after you.
Thank you, sir. Next question, Saurabh.
Mr. Venkatramani.
Yeah.
Mr. Venkatramani, you can please ask your question.
Good evening, sir. My question is, when this bill is bringing in a lot of onerous responsibilities on the valuers in terms of they being required to give opinion which are consistent with the requirements of the market, consistent with the requirements of the asset that is being valued, they need to be in a position to access a lot of data. Certain amount of data is publicly available, but certain amount of data, like for example, old maps, some sketches, some government documents, and these kind of documents are available only in the government offices. When we go there, we need to be empowered as an authorized officer to go and demand those particular papers. Now, there is a precedent in the Estate Duty Act. As per Section 4 of the Estate Duty Act, a valuer is considered to be an authorized officer for that particular act, and he can seek and require and get any document that he requires so long as they are consistent with the requirements. A similar enabling provision should be there in this particular bill so that a valuer gets some kind of a legal backing to go and demand certain papers. If he has to go through RTI acts and such things, it is going to be taking huge time to get documents. That's all.
I think you have to allow the profession to develop, and any profession, when it develops, it creates also a lot of resources on its own. So today, an economist does some modeling something, it does not go to any government office for data. There are data, much more sophisticated data, sophisticated models, machine learning, artificial intelligence, so many things are available, but these are facilitated by the regulators of the professions. And why Valuers Institute has been created? Again, please see that the thinking behind this. The thinking is that valuation is not just a profession, it has to be a discipline of knowledge. There's a lot of focus on research. Valuation Institute is created mostly for research work. While you as a valuer in practice, you can't give time to do research, move ahead in the frontier areas, work in frontier areas. How to use technology in your work, how to use data in your work, all these things, there are a group of people who will be researchers with the Valuer Institute or Valuer Professional Organization, even the National Institute of Valuers. They will provide this support to the valuers. It's not that we do in a very small way in IBBI, or advocates do also. So what advocates, Bar Council does, every advocate needs access to some online case laws which are very costly. I think they're very, very hugely costly. So one person cannot afford it. But there's an arrangement that the Bar Council gets access with 100, 200, 5,000 user IDs. And then every advocate uses that. So these are the things which will develop. That's where your Valuer Professional Organization will compete to improve its quality of its members. Valuer institutes will compete to improve the quality. When both of them are competing to improve the knowledge base, quality, technology, all these things will fall in place. But this will take at least 3, 4, 5 years to really pan out.
Thank you, sir. Next question, Saurabh. And we'll not take more.
Mr. Bhavin Patel.
Okay.
Are you able to hear us, Mr. Bhavin Patel?
If he is not there, then move on to further. He is
Mr.
not there.
Rajan.
Hello.
Hello. Mr. Shambhu, you can ask your question, please.
Good evening, everyone. My question is related to inspection and investigation, that is section number 31. Why is random inspection required to be carried out every year for valuers, even unless there is not a complaint? So because so many valuers are running their setup from a small offices and from sometimes in the own house. So we are not that comfortable. So is there any precedence of such random inspection from any other profession like lawyer, chartered accountant, or company secretary?
Please, as I told you, we are moving ahead. And as I told you, you are being groomed to provide valuation service in the world. We can't remain what was working so far, and that's why I gave you the example of National Medical Commission Act, and think how the world is moving, and we all need to move together ahead. Inspection does not mean going to your house and doing the inspection. Today you have seen a market inspection of SEBI. Rarely they do physical inspection. So now the times are changing. Inspection will be online from a distant place. Nobody will come to you. So inspection is a word only. Inspection does not mean somebody comes to your office. That is one. Second is, whenever there is a complaint, not that every complaint should result in inspection, because there will be always people, your enemies, they will file complaints. So the regulator has to choose. That's all detailed procedure. Suppose I told you repeatedly, I can say, if it is somebody is questioning the merits of a valuation, it cannot be entertained. But over and above this complaint-based inspections, to ensure regulatory compliance, every regulator does a routine inspection of 0.5% or 0.1% of the regulated every year, and that happens by a random number basis. It's not that somebody picks up A and B. There's a formula, there's a sampling technology. You do 1% of the valuers or company secretaries or insolvency professionals and satisfy yourself as this 1% have followed the rules, then everybody has followed. So there are standards, sampling techniques, and this will cover every year some percentage of people, just to give an assurance that everybody is complying the law.
Next question, and Mr. Saurabh, we would like to take only 2 questions more. It's already over 5:30.
Sure, sir. Mr. Srinivas?
Yes, sir. Sir, can you hear me?
Yeah, we are able to hear you. Please ask your question, please.
Good evening, sir. Sir, in land and building valuations, generally there shall be a large gap between the actual market transaction and the documented values as per registered title deeds. It will be difficult to produce documentary evidence for an opinion on value, which a valuer gives factoring many relevant parameters that define the value of a property. So the question is there any deterrence for false complaints by vested interest of users on gullible valuers? And are there any penalties for users on frivolous complaints made against the valuers?
I think I told 2 things. I told to deal with the frivolous, there is a detailed process of fact finding, the show cause notice, adjudicating panel, 2 layers of appeal, principles of natural justice, and proportionality. But the most important thing I mentioned is that nobody can question you on the merits of valuation unless it is mala fide. So please remember that unless it is mala fide, nobody is asking you question. But if you are mala fide, everybody must ask you. Indian Penal Code should be up to date. Please don't ask for protection or mala fide things. And if you are genuine, bona fide, nobody will question your things on merit. As regards the land and building you asked, as I told you, it all depends on the caliber of valuers will differ. All valuers can't be of the same caliber. Somebody has more capability, is able to more resourceful, is able to do a better work. Somebody does not have that ability. That kind of a quality difference will be there. But valuer does valuation. In fact, you people who should be able to answer this question better, but this is a practice question, not for me actually. At practice, how do you handle, how do you write disclaimers? How do you ensure that these 10 things must be done before I give a report? If I am not getting this, then I would say that this report is not reliable, or I am not able to give report. I will withdraw myself. This cannot be done in valuation. Or I'll say, yes, I have done 80%, 90%, but I have not done 100%. I tell the limitations of the work that has been done. But as I told you, this is not to compare with the market value. Valuer gives a valuation, as I told, it is more authentic than the market. Market can be spurious, market can be manipulated, but valuer cannot be. That is our intention.
Thank you, sir. Next question, sir.
Mr. Naveen Agarwal.
Hi, sir. First of all, it was really an honor to understand the draft valuers bill nitty-gritties from you. So my question is regarding qualification and experience. Sir, under the registered valuers and valuers rules 2017, graduates under the specified discipline for the asset class, plant and machinery and land and building, or a person holding a degree equivalent to graduation is eligible for registration as a valuer. But under the draft valuers bill, the person having equivalent qualification to graduation has been removed. So I just need to understand what was the thought behind removing the equivalent word from the draft valuers bill. And my next question is regarding the experience. Sir, under the draft valuers bill, for a person who is a postgraduate in finance, he need to have a 3 years post qualification experience. But in the similar line for the plant and machinery and land and building valuer who is a postgraduate, the experience requirement is for the 5 years. That's the question, sir.
No, actually, I am not going to answer this question, because these are, as I've told you, these are temporary provisions, and these are the things on which people would have many views, include this qualification, that qualification, 3 years, 5 years. You give your suggestions and government will take a call on this. These are actually nothing very hard and fast thinking on this.
Thank you, sir. Thank you. Last question, I think, Saurabh.
So the last question, can Mr. Sanjeev Kumar Jain.
Good evening, sir. Are you able to listen me?
Yes, sir. We are able to listen. Please
Yes.
Sir, my question pertains to the fact that the draft has made in regard of the professional fee. It says that the fee should be decided by the market, whereas the IBBI has floated a circular addressing the IPs in regard of the fee and the other expenses incurred for CRIP. On the similar lines, to ensure parity with the fusion of healthy competition, it is requested to include a clause stating transparent guidelines as regards quantum of fee, timely payment of fee, and the procedure and limit of lodging complaints in case of fraudulent activities and the malified intentions, and also the misconduct from the side of the appointing authority. Moreover, an advisory could be made to the valuers indicating a broad outline for charging a reasonable fee. Here the point is, what is reasonable enough should be covered, keeping in view the points such as the intricacy of the case, time motion study, and the fixed costs which are liable to incur. This holds relevance that there has been some cases in which IPs have charged a nominal fee of ₹1 and sometimes as exorbitant as ₹5 crore, which reflects there is some insufficiency as system as regards the fee grid. An elaborate ruling should be in place to ascertain the the reasonability of the fee case to case. Sir.
Okay. I think you have done enough study about the insolvency profession, and you would have seen an order of mine where the same submission exactly was made before me. What is reasonable? How do we know? Why not you define what is reasonable? And to that, my answer has been that it is unreasonable to ask to define reasonable. That is not possible. Like as you told, IBBI has given some circulars about fee. That means you would expect similar circulars, guidelines from National Institute of Valuers. That is not part of the Insolvency Bankruptcy Code. That is not part of the Valuers Bill. Those are the market things which will develop from time to time. These cannot be cast in iron in the Act. So bill matters are not dealt in Act. Next, the one what you told is that something will be part of a CRP cost. It still did not say that how much fee to be paid. It told that whatever fee you are paying, you have agreed to pay, that fee will be considered part of the CRP cost. Yet IBBI or its laws did not specify the amount of fee. No profession, advocate profession, medical profession, there is no schedule of fees for a doctor or a chartered accountant or an advocate. If you do that, if you have a fee that 100 rupees for this work, then you will not have a Dr. Neeraj Trehan or you will not have Mr. Harish Salve. So if you want quality, if you want the profession to move ahead, it is not a profession which is only will do a mechanical work with a calculator with it feeds 3 inputs and there is an application available on website and it gives a figure. That is not the profession is about, and that is not what we are talking. That just acquire 3 applications, 3 databases, feed it, get the data, and give it to client. So it is much more than that, which cannot be quantified. The skill of each valuer is unique, and that skill requires demands different prices. So market should ideally deal with the price. That's why the Act has not dealt with it. But if a need arises, the National Institute of Valuers is empowered where to regulate, when to regulate, to what extent to regulate. That flexibility remains.
Thank you, sir. I think we'll call it off for the time being. And sir, in your presence, I would like to request all the participants, as you had also told them, it would be better that all of us upload our suggestions and our concerns on the website of MCA, as well as they can also send us so that we can compile and in a way we can forward. And it becomes our duty also, our fraternity's duty to raise their concerns. And that was all that we could, that's why we were here and we organized so many webinars and so many discussion platforms. And Dr. Sahoo, I think you have fairly given, you addressed all concerns, I would say in detail, not the major concern, but in as a specific this thing. And of course, we were explaining people as being a part of the committee, you very well said. So to my best of abilities, I was doing that. But the way you can explain, because being an, I would call you an architect of this valuers bill. So the way you can explain, nobody else can explain like that. And you have explained. And I think our participants and other people's, their all concerns should have been addressed by now. And now it is still time, because 28th May is the last date. So sit back and review and reconsider your views, your suggestions in view of what Dr. Sahoo has explained today. And with that, I think we call it a day. And thanks for all the thanks to all the participants. Thanks to our President IOV, Mr. P.K. Thiagarajan ji. Thanks to Mr. Pawan Kumar, Mr. Dr. Devjyoti Chaudhary, and the guests from MCA. And of course, a very big thank. I feel obliged, sir. Your presence makes us progress, to look for the progress we require, with your blessings and your wishes. And I know that those are there. Thank you very much, sir. Thank you very much.